Hi. So, whenever agreement of sale is entered, one of the most important term will be time. Terms, there may not be any ancillary, implied or express clauses, but for time, there will be a clause called the time is not the essence of this contract. If it is not written, it is presumed that time is not the essence of the contract. If it is written, then time is the essence of the contract. So, the presumption in the transactions pertaining to the purchase of immovable property is that time is not the essence of the contract. Why time is not the essence of the contract, and what is the meaning of the expression time is not the essence of the contract? I am going to share it in this video. So, when a transaction pertaining to purchase of immovable property is made between buyer and the seller, buyer pays some initial amount. Unlike purchasing any other property including a movable property, the transaction pertaining to immovable property is done differently, unlike a transaction compared to a movable property. If you are buying a television, you simply go to a store and purchase a television. Time is not the essence of the contract here. But in real estate transactions, in the transactions pertaining to the immovable properties, why time is the essence of the contract or time is not the essence of the contract? Because some margin money is paid, and after some time the balance sale consideration will be paid. Nobody will purchase an immovable property like purchasing a television, because there is huge due diligence to be done while purchasing an immovable property in India. So therefore some amount is paid as a margin money, and the balance amount will be paid after a certain time and followed by registration. So therefore time is not the essence of the contract. Therefore there is a presumption. Presumption means which need not be proved. If you want to make time the essence of the contract, then you have to specifically mention an ancillary term pertaining to not performing the contract within the time period. What is the damage or the compensation that is paid by the defaulting party if the balance payment is not paid within the time? There could be many reasons. One of the reasons could be some permissions from the government. In the instant case, in a recent Supreme Court judgment, the ancillary term was permission from the government to do the transaction, to execute the sale deed, which was not completed by the seller within the stipulated time. Therefore, seller proposed to cancel the sale agreement as per the terms and conditions in the agreement, for which the purchaser kept silent for 2 years, and after 2 years, when the defendant got permission from the government, purchaser tried to pay the balance amount, but the seller did not permit, and therefore the purchaser went to the court for executing the agreement or performing the agreement of sale. Finally, it reached Supreme Court, and Supreme Court gave a decision in favor of the seller and directed the seller to return 15 lakhs for the 15,000 paid in 1978. So around 44 years. So what we must understand from here is that whenever you are entering an agreement of sale, it is presumed that time is not the essence of the contract, because delay can happen, because the transaction is not done in one go. It is made in two parts, and when the transaction has two parts with a time period, anything can happen. So how could time be the essence of the contract? Parties may die, there could be permissions to be obtained, there could be 101 reasons that can happen within the time period. Therefore, time is never the essence of the contract in the transaction pertaining to the agreement pertaining to the immovable property or purchase of property as per the Transfer of Property Act. That is why there are huge failures, huge number of cases pertaining to specific relief act, specific performance, pertaining to agreement of sale. So therefore, whenever you want to make the time the essence of the contract, you have to specifically mention the ancillary term pertaining to time. That is to say, if it is not performed, these are the penalties. If it cannot be performed subject to, they all become the ancillary terms. So when ancillary terms are clearly specified, that if the transaction is not performed within the time frame, then time will be the essence of the contract. It can be ascertained from the intention of the parties based on the terms and conditions in the agreement. Whenever you want to make time the essence of the contract, don't make it casual in the agreement of sale. Make it specific. It has to be very, very specific. If it fails, what are the consequences? If it doesn't fail, what are the consequences? If there is specifics pertaining to the intention of the parties, then time will be the essence of the contract. Otherwise, time is not the essence of the contract in immovable property transactions. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.